Hi there, and welcome to the Employment Law Show. Again, we're back this week. I'm John Scholes. He's Lior Samfiru from stlawyers.ca, Samfiru with Tumarkin, LLP. Reach out anytime. We'll give you the phone number throughout the show, but right off the hop, it's 1-855-821-5900. The email address we always go to is help@employmentlawyer.ca. And there was a website put together several years ago, and the whole purpose of the website is to educate you and make you smarter when it comes to workplace rights and employment laws. It's free. It's anonymous, called pocketemploymentlawyer.ca. You might be familiar with it if you're a long-time viewer of this show or a long-time listener of our radio shows as well. Contained in that is the severance calculator, which does what it's supposed to do. Give you the accurate number of how much severance you're actually owed. It's going to be a lot more generally than your ex-boss thinks, or your neighbor Steve across the fence. So again, pocketemploymentlawyer.ca, pretty much bulletproof. Use that whenever you'd like. Main topic, a little later on, guide to probation periods. Why? Because we get questions about probation all the time from employees and employers. A lot of people are in the dark about this one, so we're going to clear that up a little later on in the show. That and some phone calls as well from one of our radio shows. I'll tell you how to reach us on radio in just a little bit as well. But Lior, you know, we always get warmed up, as you say, stretch our legs, etc. with the week that was, our case of the day. What do you got cooking?
Hey, John, employment law is what I got cooking in a shocking development.
Right.
This is what I like to do, but this is what we want to do on the show. Make sure that you have all the information you need to know if you're working, if you lost your job, if you're looking to accept a job. What should you do? What should you say? What does the law do for you? It's okay to ask, what does it do for me? That's why we have laws. The laws are not there for you to do something for them. They do something for you. They protect you. They give you rights. They tell you what's proper and what's improper. And we have some really, really good employment laws, but they can be confusing. And sometimes it's not clear if this law applies or if it doesn't apply. Well, on the show, we try to make it as simple, as straightforward as possible. We tell you what you need to know if you're in a workplace situation that's not appropriate or that's difficult, challenging. I often get called by people that are given an ultimatum by their employer. You have to make a decision about this new job, about this new pay, about these new terms of employment. They don't know what their rights are. Can their employer even do that? We go over those issues all the time. You'll understand what your rights are. But of course, beyond the 30 minutes of the show, we can only fit so much information into 30 minutes. I'm not going anywhere. I'm going to maybe unbutton the jacket, get a bit more comfortable, and go work in the office. And that's when you can call me, you can email me, so we can have a private discussion about your personal, your private situation. But to get us started, let me tell you about a matter that came across my desk just earlier this week. I spoke with a gentleman who had been working for the same employer for over 28 years, and he was an older employee. He had just turned 66. Well, he was called into a meeting, and he was told by his employer, well, we think now it's about time that you be a team player and retire. We want to bring new blood into the workplace, and we'll even be nice to you. Even though we think you should retire, we'll pay you for 6 months. We'll give you a 6-month severance offer, and we want you to make that move and free up that position for someone else. Well, he was offended, he was upset, he was insulted, but at least he knew that that was wrong, and that's why he called me. And his question was very simple. Can they do this to me, and how do I respond? So the answer here is very clear. No, they cannot do this to him. You cannot be told you should be retiring. You cannot be encouraged to retire. You cannot be threatened or pushed into retiring. First of all, mandatory retirement, that's gone. It's been gone for many, many years. But beyond that, your employer cannot push you to do anything with respect to your employment if it's based on age. No decisions can be made by your employer if they're motivated by your age. That's age discrimination. That's a human rights violation. The law takes that very seriously. So if your employer pushes you to retire because of your age, or they let you go even in part because of your age, that's illegal. And of course, if they let him go after 28 years, he's going to be owed 2 years severance, not, of course, 6 months severance. So what I told him to do is this. I told him to put it in writing and say he's not retiring. He's going to continue working until he decides he no longer wants to work, and that's it, that he doesn't want to hear anything further about it. If they do anything other than back off completely and let him continue his job, that would be a human rights violation. That could be a wrongful dismissal, wrong and illegal. But I want our viewers to remember, you can continue working as long as you want. And by the way, if you're starting maybe in an older age to have some physical limitations, you can get a doctor's note that talks about those limitations and gives your employer information about the accommodation that you may need. You can continue working as long as you want, And if your employer does anything other than help you and support you, please call me.
What if, Lior, what if it's not to the point where you've actually been let go and, you know, you're crying ageism, and you're right in that regard, it could be. What if it's a little more subtle? You know, you come in, you've got pamphlets for Trembling Pines, you know, retirement community on your desk. You're like, guys, really? You know, it'd be a good day for you to go golfing. I know you're a little sore, but don't have to work today. Go golfing. Take a few days. It's subtle things where they're kind of pushing you out the door. How does an employee deal with that?
Well, in that situation you've described, essentially the employee is being told, you're too old to continue working here. You should be doing something else at your older age. Well, that's wrong. You can't be told that, and that in itself could be a human rights violation. And of course, because of that creates an uncomfortable work environment. How do you continue showing up to work every day where your boss is clearly sending you that message that you're too old to be there? So that could be a constructive dismissal. You may be able to treat this treatment of you, the way your boss is conducting him or herself, as a termination, as a constructive dismissal. So no, an employer should never do that. Now, it's okay to ask the question, hey, we just want to be ready. Are you planning on retiring or no? That's okay, because if you are, they may need to make sure that they have someone to replace you. But beyond that simple, straightforward question, it's inappropriate to encourage you to retire, to leave pamphlets with golf courses on them. Wrong, and that even an employer that means well could be guilty of a human rights violation.
Now, if I'm an employer, Lior, watching the show going, yeah, Lior, but I got a couple, you know, 1 or 2 employees there. You know, we love them. They've been there for years. They're really good, but they're not cutting the mustard. They're getting a little slow. How do you approach them and say, you know, do you need help? Can I assist you with this? So on and so forth, right?
Well, you can certainly ask the question. You can ask the question, is there a reason why we've noticed your performance dropping? Is there something that we can do to change that, to turn that around? That's a legitimate question. A good employer would do that. Now, if an employee says, no, everything is fine, then an employer can engage in performance management like they would with any employee. If your employee is not doing a good job, write them up, give them a warning. And if it continues and you've given them warning and opportunities and they're not improving, they're not giving you a reason as to why they're not improving, yeah, you may even consider down the road a termination for cause. But to simply ignore it or to simply let someone go because of their age, that's never allowed.
EmploymentLawyer.ca. Always remember that website. Among other things, you will find a radio station close to you in your neighborhood where you can catch our weekly radio show, Lior and I do. You're always encouraged to call into that show, and maybe your phone call will appear on this show. We'll talk about it. If it's interesting, it's something that the rest of the viewers can learn and benefit from. So we'll get to our first one for this show. Phone call number 1 is coming right up.
I've been with the company for 35 years. I'm 53 years old. We're downsizing again, and they announced a plant closure. And I've been on the severance pay calculator, but it tops out at 25. It says 25 or more years. I haven't received a package yet. I'm supposed to be receiving a package, and I'm just kind of wondering where I stand.
What type of position did you have?
I'm a foreman right now.
Oh, use the calculator. First good move, right?
Yeah, and I think what he's referring to is in the categories you can choose on the severance calculator, it says 25 years plus of service, and he's at 35 years, but it still works just the same, still applies. Now, the one thing I want to make it clear here, the plant is closing. So he's saying the plant I work for is closing. Well, that may be true, but that does not mean you don't get severance. If the business you work for is shutting down, if it's closing its doors, the severance obligations remain the same. You still have to get paid what you are owed. Now, this gentleman scores high in all 3 categories. In a senior position, he's a bit older, he's been there for 30 plus years. So he's going to get a substantial amount of severance. He mentioned the severance calculator. Well, how do you use it? Let's take it out for a spin right now. Let's see what the severance calculator gives us. We'll go to pocketemploymentlawyer.ca. We'll plug in the information to the severance calculator, and let's see what we have. So he's a foreman. He's been there for 35 years, a very long time. He's 53 years of age. We don't know yet what this company is going to offer him for severance, but what we do know is that he's owed as much as 24 months severance. Now, this says 22 to 24 months. I'm telling you it's 24 months. After 35 years, he'll get the maximum, which is 24 months of severance. So that's how easy it is, John. You just go to pocketemploymentlawyer.ca. It's completely free, completely anonymous, takes a few seconds, and you'll know what the right severance for you is.
You bet. Phone call number 2 before we go to a break is coming up right now. Listen up.
Well, I've been truck driving for this company for the last 2 years as a contractor. That was my sole employment. And then when I was on the road, my paycheck had not come, so I messaged their payroll. And I got a message back saying, hey, we've gone bankrupt, you're not getting paid. So they kept 3 paychecks, and then later on we find out they've not even actually claimed bankruptcy yet. What's my rights in the situation?
2-year sole employer contractor.
So this, by the way, truck driver, this happens all the time with truck drivers when they're being called, or I'm going to say misclassified as contractors. So if you're a trucker, chances are you are an employee. You're not an owner-operator or a contractor. In most cases, if you work for one company, you're an employee of that company. As simple as that. Why is that important? It's important because if you really are an employee, you have the rights of an employee, including, vacation pay and overtime pay, and of course the right to get severance. So in this case, if he lost his job, he's owed severance. He mentioned bankruptcy. If the company is truly in bankruptcy proceedings, he's not going to be able to get severance, very likely, although he may still be able to get paid for his unpaid wages. He has very high priority in the bankruptcy process for those unpaid wages. But if the company is not actually in bankruptcy, they haven't filed, they're not in that formal process, then that means they have assets, they have money, they have things that they own. They have to meet all obligations, including to pay him what they owe him, as well as severance. So don't take the company's word for it that they're bankrupt. We can always do a proper search to determine if that is the case. Hey, and if you're a truck driver, chances are you are an employee.
All right, we'll take a short break. Guide to probationary periods coming up in just a bit, and phone call number 3 for this show is on the way as well, so stick around for that. Listen up and continue to watch us here. In the meantime, the phone number to get a hold of Lior, 1-855-821-5900, and our email is help@employmentlawyer.ca. We continue with more of the Employment Law Show. Hang in there. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Employment Law Show. We have our third phone call coming up here and our guide to probation after that. But anytime you want to reach out to us, you can go to employmentlawyer.ca, find a radio station in your market that carries our show, listen to us, and call in, talk to us. You may appear on this show. So, Lior, let's get to it. Phone call number 3 from our radio shows right now.
Been working effectively from home for the last 4.5 years. And they're slowly insisting that everybody come back. If you will not come back, you're out. So could I approach them to ask? They say, well, if you don't come back, you're finished. Could I ask them, will you give me a severance package? Or just say, okay, that's fine. I no longer work for you, and just leave.
That work from home threshold post-pandemic I find really fascinating now.
So this person potentially was working from home even before the pandemic. He says about 4.5 years. So let's deal with that first. And let's say that if you're hired to work from home, and you've been working from home for a substantial period of time, that becomes a term of employment. And that means your employer can't just change that. So if you've been working from home for a bunch of years, and now the company says, we want you to come back into the office, you don't have to. And if the company lets you go because of that, that's a without cause termination, and you're owed your full severance. That's not a for cause termination. It's certainly not a resignation. You can continue working from home. Now, pandemic, you mentioned. For those employees that started working from home during the pandemic, the reality is that your employer could have asked you to come back to work over the past year or so when the pandemic was essentially behind us. But if they chose not to, they allowed you to continue working from home when there was really no reason for it, it now has become a term of employment. That means they can't change it. They can't take it back. And if they do, same thing applies. You may be able to say no, and if you're let go, you can't stop them from letting you go. But if they let you go, they're going to owe you your full severance. So the key here is to not resign. The key here is to let the company make the move, because if they let you go, severance is going to have to be paid.
4.5 years, right? decent severance offer there.
Oh, yeah. I mean, we don't know the total length of employment, but even if he's only a 4.5-year employee, he could be looking at north of 6 months of severance, which hopefully will be enough for him to find another job.
Guide to probation periods. This is a question we get all the time, both on this show, we get emails, and on the radio show as well. Let's go through it. Probation periods, Lior, are not automatic at the start of new employment. That will shock a lot of people.
So just because you started a new job, just because you walked into the work for the first time does not mean you're automatically on probation. The law does not impose probation automatically. The law says that the only time you're actually on probation is if you sign an employment agreement that says you are on probation. So if you didn't sign an employment agreement, maybe you started a job on a handshake, you're not on probation. Or if you sign an employment agreement and it doesn't address the issue of probation, then again, you are not on probation. And why is that important? Why do we want to know if someone is on probation? Because if you're not on probation, if you're not actually on probation, even though you started a new job, and you lose your job in the first month, 2 or 3, you're still going to be owed severance. And yes, even after 1 or 2 or 3 months, that severance could be substantial. So probation is not automatic. You're only on probation if you signed a written employment agreement that says that you're on probation.
You mentioned, month 1, 2, or 3, and that is it. The standard probation period is 3 months, right?
So the law only allows a company to let you go without compensation in the first 3 months of employment. After that, doesn't matter what you may have signed, you're still going to be owed compensation. You're still going to be owed severance. So the practical effect of that the only time you really can be on probation is the first 3 months of employment. Because once you go past the 3 months, if the company lets you go, which they're allowed to, of course, they have to pay you your severance. So it doesn't really do anything. So if you sign an employment agreement that says you're on probation for 5 months, guess what? That's not worth the paper it's written on. And in fact, just by saying 5 months instead of saying 3 means you're not on probation at all, because that term is illegal. So an employer that says in an agreement that the probation is longer than 3 months may have made it so that there's no probation at all.
Well, it's funny because that's the third point. The employer generally cannot extend that probation period past 3 months. It's pointless.
Well, exactly. The key word is pointless. It's not that they cannot. It's just that if they do, nothing really happens. They haven't accomplished anything. Because remember what I said before. The only time you can be let go without any compensation is the first 3 months of employment. So if you've been already working for 3 months and that's going to now be extended by another 3 months, well, the employer's not doing anything because they have to pay you severance if they let you go. So if your employer feels better somehow by saying your probation has been extended, fine. But you as the employee need to know that it doesn't really mean anything.
Or they may try to use that as a tool. What I mean by that extended probation cannot be used as a means of discipline or performance management, right?
Well, I mean, it may send a message to the employee that the employee is not doing a great job, but it doesn't really help the employer. So the better way, if you want to discipline an employee, give them a letter saying, here's what you're not doing right, and we're giving you a warning that if this continues, we may have further discipline. That's the proper way to discipline someone, not to extend the probation, which really doesn't do anything.
We're talking about probation periods and trying to clear up some of that misconception for you. Last point on this one this week is employees terminated without cause during a probationary period may be owed severance pay.
Absolutely. So if you're on probation, you think you're on probation, or probation is extended, you may still be owed severance. And here's the other thing I want you to know. Even in the first 3 months of employment, you're owed severance, and that severance could actually be longer than the 3 months you've been working. You may have worked for 3 months, and that severance could be 4 months, 5 months, even 6 months. Yes, the severance period can be greater than the period of employment. Short service employees are treated disproportionately better than longer service employees. So the rule is very clear. If you lost your job, whether it's in month 1 or after many years, you call me, you may well be surprised by what you're owed.
Is that generally because just because you're short service doesn't mean you're going to find a gig sooner than anybody else?
Yeah. Well, what's the point of severance? Severance is not there to punish the company for letting you go. Severance is there to help you while you're not working and to carry you until you find another job. So just because you work for a company for a short period of time doesn't mean you're going to find a job the next day. It could still take you many months to find another job. And that's why the severance is still substantial.
All right, hope that helped. That topic on probation, lots more to come, including rapid fire a little later on the show, where we throw questions at Lior really quickly. In the meantime, as we get to a break, the phone number to reach out, 1-855-821-5900, or email is help@employmentlawyer.ca. We're coming right back. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Thank you so much for sticking around through that short break here in the Employment Law Show. Anytime we're not doing the show, you can reach out to Lior and his team. Phone number is always 1-855-821-5900. Email help@employmentlawyer.ca. And for other matters, you can simply go to pocketemploymentlawyer.ca. While you're there, take a little time, peruse, get educated with what you teach each week here on the TV show and the radio shows as well. And you'll have access to that severance calculator through pocketemploymentlawyer.ca. When he's not practicing law, doing radio and TV and taking care of his family, he does so many things. He's doing live streams as well, Facebook and YouTube. I don't know how you keep all the plates spinning, pal, but somehow you do. Get a lot of good questions on it. If you want to join that live stream, you can do it at ST Lawyers, at ST Lawyers. Lior, this week, I was recently let go from my position after 6 years in a tech role. I'm 45. I was not offered severance, but I've heard that the company will be adding 2 weeks' pay to my final paycheck. If I accept the money, does that mean I've agreed to accept this as my severance? I guess kind of a final offer thing, right?
So I get asked variations of this question often, so it's a good one for us to discuss. So what happens if a company is simply paying you the amount that they think you should be getting? So they're just giving you a check or they're putting it in your account. If you take that money, are you considered to have accepted it? Because you may think, well, they owe me more. So if I take whatever it is that they've paid me, aren't I considered to have accepted, and am I stuck then? The answer is no. If the company actually gives you money on account of severance, even if it's less than what you're owed, even if you're about to talk to me so I can get you more severance, you're fine. You're not accepting it by taking that money. If they put it in your account and you use that money, you're not considered to have given up your full severance entitlements. It's absolutely fine. The only way you can give up your severance and consider to have accepted is if you sign a piece of paper that says, by taking this money, you agree that we owe you nothing more. So unless you signed a piece of paper like that, you're fine. You can use the money that the company gave you, and you're still going to be able to get your full severance. Now, in this particular situation that you read, John, this person after 6 years was let go, and he thinks the company is just going to give him 2 weeks' pay. Nonsense. He's owed much, much more than that. So I'm going to go back to my favorite tool, to pocketemploymentlawyer.ca, use the severance calculator so we can see the real amount, what he's truly and absolutely owed. So we know that he's in a technical role, been there for 6 years, 45. Company says, yeah, here's a couple weeks' pay. Not so fast. You see right there, he's owed as much as 8 months, not weeks, months of severance. That's a lot more than 2 weeks, and that's what's at stake here. And for you as well, if you lost your job, I want you to go to the severance calculator. I want you to always call me, because you may be surprised, shocked in fact, by what you're actually owed.
That's a lot. 2 weeks, I mean, that's, you know, we go through a lot of these on the show every weekend, our radio show as well, but that one's really weak. 2 weeks compared to that many months?
Well, it's obviously an employer that's ignorant about their legal obligations. I've seen it happen. I've seen even worse than that. Doesn't matter. Big company, small company, chances are you're still owed much more.
And again, tech role doesn't matter. All components of his compensation must be included, yeah?
Yes, and we don't know. He may have, you know, a tech role. He may have stock options. Those could be worth a lot. So those have to be included and addressed for the severance period. He may have commissions that he earns or bonuses that he's expecting. I can almost guarantee you that a company that lets an employee go may say, we're not going to account for your bonus during the severance period. It's discretionary. Well, guess what? It's not discretionary. If you always get a bonus, then the company has to pay you because you would have expected to get one if you had continued working. So bonuses have to be included as part of your severance as well. That's why it's so important to call me.
Another way to reach out anytime to Lior and his team, that is terminationquestions.com. Again, terminationquestions.com. It's free, it's anonymous. We'll get to a question from that as we roll down here in the last few minutes. It says, over a year ago, a manager started behaving inappropriately towards me. Some extremely derogatory comments and slurs were made. After filing a complaint with HR, my pay was slashed. I eventually resigned. Do I have any rights or is it too late? Wow.
How do I even begin with this, John? Well, let's start talking about legal rights and legal obligations. So, of course, every employee has the right to be treated properly in the workplace, to work in a healthy and a supportive work environment, and not to work in a poison work environment. And what happens if you're being mistreated, bullied, harassed, etc.? Your employer has to take that seriously. You have to tell your employer, and they have to take it very seriously. They have to investigate and fix the problem. And what they cannot do, ever, is penalize you, let you go, reduce your pay, do anything to you. They cannot. That's illegal. That could be a violation of several statutes. It's wrong, and that can happen. Now, in this particular situation, this employer obviously didn't get the memo. And instead of dealing properly with the harassment, they punished this employee. They reduced his pay. And because of that, he resigned. Well, that's not a resignation. If your employer treats you that way, that's a constructive dismissal. Depending on the harassment, that could also be a human rights violation. That could also be a violation, as I said, of a couple of other statutes as well. So whenever you're being harassed, I want you to talk to your employer. I say talk, but what I really mean, I want you to send something in writing. An email works well, telling your employer what happened, and telling your employer that you expect them to deal with it. You don't want your employer to deny that they knew about it. And once you tell your employer, they have the obligation to take it very seriously, even if it means bringing in an outside investigator, dealing with that issue. And if they do anything other than properly deal with it, you call me.
Even if the boss is the one doing the harassing, it goes straight to you, right? You have to.
Now, if there's no one to talk to your point, maybe it's the owner of the company that's harassing you. Who are you going to go? There's no one above him or her. Well, at that point, because you can't deal with it internally, we'll deal with it externally through me, and that's when you call me.
It is time for Employment Law Rapid Fire. Let's get into that, shall we? Okay, number one, here we go. Rapid fire questions. Lior, should an employee wait to be recalled from a layoff?
Absolutely not. An employer does not have a right to put you on a temporary layoff. And by accepting it and going back to work, you've given them the right to do it again and again. That's a terrible situation. Instead, you may be better off to consider that to be a constructive dismissal.
Number two, are employees permitted to electronically monitor employees? What's that about?
So generally speaking, an employer can try to find out or monitor what you do during work hours, but only during work hours. And of course, that has to be done in a reasonable way. So they can have a tracker, for example, on a phone or a company computer. That is okay. But if it goes beyond that, if they track your activities beyond work, that is offside. So that's where the line is drawn.
Can employees extend an employee's probation?
We talked about that. The answer is no. It becomes meaningless.
Should employees provide notice before resignation?
Yes, an employee does have to provide notice. Now, how much notice may be stipulated in an employment agreement? If it's not, you have to provide a reasonable amount of notice. So be fair with your employer.
We'll get to number 5 here in the rapid fire. Are employers obligated to honor annual bonuses?
Yes. Yeah. So if you're getting a bonus every year, that bonus becomes a term of employment, part of your compensation, and the company can't just take it away. That could be a reduction in pay and maybe a constructive dismissal.
One final one, Lior. Here we go. If your employer is bought by another company, do they have to keep you on as an employee?
No. If a company is bought, they don't have the obligation to keep you on. In many cases, they will. If they do, you want to pay attention to that employment agreement. But if you lose your job as a result of a sale of a business, that's a severance as owed.
Got her done. And you want to reach out now to Lior with any of these questions, you can do so. Here's how you do it. help@employmentlawyer.ca and 1-855-821-5900. We'll catch you next time.